Okay, welcome everyone. Thank you so much for joining us. I'm Ann Bloom. I'm the Executive Director of the Civil Justice Research Initiative, a think tank on access to justice issues at Berkeley Law School. Our program today is on the effects of ideology, race, and gender on class certification decisions. The program is part of a series of research-based presentations that are supported by a generous gift from the Robert L. Habush Endowment. Our speakers today are Professors Stephen Burbank and Sean Farhang. Professor Burbank is the David Berger Professor for the Administration of Justice at Penn Law. He's the author of several definitive works on federal court rulemaking, international civil litigation, litigation retrenchment, and judicial independence and accountability. His 1982 article, The Rules Enabling Act of 1934, reoriented the theory and practice of court rulemaking. Professor Burbank's recent scholarship includes a detailed study of the Class Action Fairness Act of 2005 and an empirical study of the retirement decisions of federal judges. His recently published book with Professor Sean Farhang, also with us today, is called Rights and Retrenchment, the Counter-Revolution Against Federal Litigation. And the book uses original archival research and data sets to map efforts to scale back private enforcement of federal law. Professor Sean Farhang is Professor of Law, Political Science, and Public Policy at the University of California, Berkeley. Professor Farhang's research interests focus mainly on civil litigation and the role of litigation and courts in regulatory implementation, with a particular interest in the political and institutional forces that shape litigation. Professor Farhang's first book, The Litigation State, Public Regulation and Private Lawsuits in the United States, examines the sources of private litigation in the enforcement of federal law, and it won the American Political Science Association's prize for the best book in the field of US national policy. In addition to the book on rights and retrenchment that he published with Professor Burbank, Professor Farhang has also published numerous articles on the institutional and political dimensions of American civil justice. Professors Burbank and Farhang, thank you so much for joining us today. We're really looking forward to hearing about your research on the effects of ideology, race, and gender on class certification decisions. For the audience, I wanted to let you know that at the end of the presentation, we will have some time for questions. You can send your questions in using the Q&A feature. I'll keep track of these and share them with Professors Burbank and Farhang after the presentation. Otherwise, I just want to thank Professors Burbank and Farhang again for joining us, and I think we're ready to begin.
Well, thank you, Ann, and thanks to your organization for inviting me. It's great to be back at Berkeley. I wish I were there in person rather than virtually. I had a wonderful visit at Berkeley a few years ago when Sean and I were finishing our book. The article we're going to discuss today is part of a larger project that studies the class certification decisions of the United States Courts of Appeals from 1966, when Rule 23 was amended to give us the modern class action, through 2017. The larger project, in turn, was stimulated by our work on the counter-revolution against federal litigation. We found in that work that of all the pertinent lawmakers, only the Supreme Court achieved notable and consistent success in changing the law so as to promote retrenchment of rights. Moreover, we found that in decisions interpreting federal rules of civil procedure pertinent to private enforcement, including, of course, Rule 23, justices' votes were more influenced by ideology, and the justices themselves were more polarized than they were in private enforcement cases in general or in cases adjudicating substantive rights. Understanding that the Supreme Court has limited resources to superintend the development of federal law, we decided to investigate circuit courts' interpretations of perhaps the most controversial federal rule, one whose catalytic potential for private enforcement fuels that controversy. And intrigued by our findings about the ideological complexion and extreme polarization of the Supreme Court's federal rules decisions, we decided to start by exploring the relationship between the ideology, gender, and race of U.S. Court of Appeals judges and decisions addressing class certification under Rule 23. Underpinning battles over the ideological, gender, and racial complexion of the federal courts is an implicit empirical assumption. The ideology and identity of federal judges matter to how they decide some cases. It is no wonder then that the relationship between judge characteristics and judicial decision-making is among the largest fields of inquiry in the social scientific study of courts. We wanted to determine whether the ideological cast of the Supreme Court's class action decisions reflects a more general phenomenon. And if so, we wondered whether the power of Rule 23 to elicit ideological voting might signal that decisions on class certification also trigger distinctive race or gender preferences akin to those that prior research found confined to a limited range of issues in the domain of discrimination law. We start by briefly reviewing the literature on Court of Appeals decision-making that we build on. Scholars have done substantial work, empirical work, on the role of ideology, gender, and race in judicial decision-making on the US Courts of Appeals. However, the field has largely ignored procedural law, including class actions. Scholarly neglect of the possible influence of ideology is not surprising, although it is regrettable, regarding procedural law in general. It is more puzzling with respect to class actions in particular, which have long been the subject of ideologically inflected debate. The neglect of gender and race as possible influences on class certification decisions may arise from an apparent consensus that has emerged in the literature on the Courts of Appeals, that judges' gender and race are associated with variation in preferences only in a narrow band of cases directly and explicitly implicating discrimination and inequality. Because of this view, we surmise, scholars interested in the effects of gender and racial diversity on the bench have not regarded procedural law as a productive avenue of inquiry. Even procedural law like Rule 23 that importantly affects access to justice and does so across substantive domains. We then review the theoretical accounts of appellate decision-making that provide possible explanations for panel dynamics when judges in the panel minority in terms of preferences do not affect outcomes and when they do. By minority group, we refer to groups of judges that are a numerical minority on the US Courts of Appeals, such as women, non-whites, and theoretically, ideological minorities, regardless of their numbers in the general population. We use the phrase panel minority to refer to a minority position on a panel that has divided preferences, regardless of whether the judge is in a majority or minority group on the circuit.
So I'm going to enter now. Thanks a lot for being out there. In order to study empirically courts of appeals, the relationship between courts of appeals judge characteristics and the outcomes of cases or the votes of judges, it's extremely important to recognize that Court of Appeals decisions are overwhelmingly unanimous. And this is true even in ideologically contentious issue areas. For example, in our data that we're going to discuss, all Democratic panels have nearly triple the probability of certifying relative to all Republican panels. And yet, on mixed panels, the dissent rate is only about 3%. Thus, even though there's very substantial variation in preferences over certification that is associated with party, nevertheless, mixed party panels overwhelmingly achieve unanimity 97% of the time. Scholars and some judges have puzzled over what mechanism is causing this high level of unanimity, even in contentious issue areas, and they've come up with a lot of ideas. One group of ideas we characterize as the suppressed dissent hypotheses. And the idea is there are incentives that disincentivize dissent, heavy workloads that leave judges limited time. Heavy workloads, hold on for 1 second. Heavy workloads that leave judges limited time to write dissents, institutional norms on the courts of appeals that discourage dissents, or the loneliness of dissent. These suppressed dissent hypotheses, minority preferences on panels just simply get outvoted in majoritarian processes, but they go along because it's the easiest thing to do. There's an alternative story that we characterize as the modified content hypotheses. And this story says that other mechanisms, particularly deliberation and bargaining, are such that minority group judges do not dissent precisely because they do affect outcomes by changing the minds of co-panelists with deliberation or getting concessions from co-panelists in bargaining processes that lead to unanimous decisions. This question of the debate between the suppressed dissent hypotheses and the modified content hypotheses is important for thinking about the representation of numerical minority groups like women and racial minorities on circuits. The reason for that is that a group that holds a minority of seats on a circuit is going to be in the majority of panels an even smaller fraction of the time. So for example, if a group holds 20% of seats on the circuit, they're going to be in the panel majority only 8% of the time. And thus, if they're only affecting the application and development of law in the majority, then their influence is substantially smaller than their share of seats on the circuit because of the majoritarian character of three-judge panels. We characterize the suppressed dissent hypotheses as applied to the context of minority groups as having pessimistic implications because they would obstruct the ability of minority groups to influence the law commensurate with their numbers, and of course they're already underrepresented. Alternatively, we characterize the modified content perspective, the influence of a minority on a panel through deliberation and bargaining, as offering, at least relative to the suppressed dissent hypotheses, as having positive normative implications and leading to an optimistic conclusion about the ability of minority groups to affect the development and application of policy on these three-judge panels. We tackle this empirically by collecting data. We compiled a comprehensive data set of over 1,300 Court of Appeals decisions addressing whether or not to certify a class. The models that we're going to discuss below are ones that are restricted to 2002 to 2017 because that's where our data is most complete. And in the models, I'm going to show you some model results. In the models, I just want to say they're extensive control variables. You may ask about some of them in the Q&A, but they're extensive control variables. And I want to say that in particular, since this question has come up a lot, all of the models include gender, race, and party simultaneously. So we're estimating the effect, for example, of gender on probability of supporting certification, already having in the model whether the judge is a Democrat. That's important, obviously, because a majority of women and African Americans are appointed by Democrats, and so we control for that potentially confounding variable. So here are the predicted probabilities that come out of the model. I'm going to ask for my slides to be put up now. I'm going to talk about party, then race, then gender. The model tells us that 2002 to 17, 3 Republican panels had a 20% probability of ruling in a pro-certification direction. And then we compare each other panel type with the 3 Republican panels to see if they're statistically distinguishable from the 3 Republican panels. When you add 1 Democrat, those panels are not statistically distinguishable from the 3 Republican panels. However, when you add 2 Democrats and Democrats go into a majority, then there's a statistically significant difference, and the probability of a pro-certification outcome is 47%. With 3 Democrats, it grows to 58%. And therefore, moving from an all-Republican to an all-Democratic panel, we see nearly a tripling of the probability of a pro-certification outcome. Perhaps you're not surprised, I don't know, that ideology matters to certification on the courts of appeals. But I do want to say that as compared to the literature, the judicial behavior literature, these effect sizes are very large. They're larger, for example, than the effect of party in models estimating outcomes in capital punishment cases, in Title VII cases, and in abortion cases. So certification on the courts of appeals is not just ideological, but highly ideological. Next slide, please. Focusing on race, our models focus on African Americans, distinguishing African Americans from white other judges. The paper goes into further detail with different groups, but what we're presenting here focus on African Americans. And what we find is that 3 white or / other, meaning other racial group panels, there's a 34% probability of certification. And when there's 1 African American on a panel, the probability of certification grows to 47%. Next slide, please. So with respect to African Americans, we find that the voting is not purely majoritarian. It's not a suppressed dissent story. Some kind of modified content is going on in which 1 African American in the numerical minority on the panel is influencing the panel majority to increase its probability of certifying. And this supports the optimistic view that it's possible for numerical minorities on panels to affect majorities. And it's consistent with some prior studies that found that this was true, focusing on race and gender, that this is true in the area where there are substantive civil rights claims as distinguished from procedural claims. I'm not going to say anything about African American majority panels because we have insufficient data to say anything. Next slide, please. The gender results show that all male panels have a 28% probability of certification. And when you add 1 woman, the probability of certification is not statistically distinguishable from all male panels. We want you to notice that's distinguished from race, whereas 1 African American influences the majority, 1 woman does not influence the majority. Well, you might say perhaps she doesn't want to, but when we look at what happens on panels with 2 women, we see there's a very significant increase in the probability of certification. Panels with 2 women have the probability of certification jumps from 28 to 49% probabilities of a pro-plaintiff or pro-certification outcome. From that, we conclude women have significantly more pro-certification preferences, but they're having no effect on outcomes when women are in the minority on the panel. Next slide, please. So, as contrasted with race, voting looks much more majoritarian on these panels. The results we see are consistent with the suppressed dissent views, which we characterize as the pessimistic view, that panel majoritarian behavior on panels could obstruct the influence of numerical minorities on the circuit. So if women are 20% of the circuit and 8% of panels with 2 women in a particular circuit configuration, their influence is far lower than their numbers on the circuit. I'm done with my slides. I'll make 2 last quick points. 1, when we drop all civil rights claims from the models, we find that the results are the same. 1 woman doesn't make a difference, 2 women increase the probability of certification, and 1 African American increases the probability of certification. That's significant to 1 contribution of the paper. The literature has converged on the idea that race and gender of judges on the courts of appeals matter in very rare sets of cases in which implicate issues of discrimination and inequality. And we find that that's not true in this paper. Even when you drop all of those cases, majority female panels and panels with 1 African American behave differently and are more likely to certify. It suggests to us that the literature has underestimated the influence of diversity on actual policy outcomes, and that trans-substantive procedural rules that affect access to justice are a domain that deserves further study relating to diversity. And I think I'll leave it there. Steve?
Okay. Neither our data nor existing scholarship allows us to identify the reasons for women and African American judges' different preferences as to class certification, or in the case of gender, why 2 women on a panel as opposed to 1 are associated with higher rates of pro-certification voting and outcomes. We do, however, offer some suggestions on both questions as a possible guide to future research. With respect to different preferences on class certification, one important insight of the article is that transsubstantive procedural law, which can profoundly enable or constrict access to justice, and which until now has been ignored in the literature on judicial diversity, can act as a transmission valve that conveys the substantive effects of diversity across the landscape of American regulatory law. Courts of appeals judges understand that the federal rules are transsubstantive, as are the effects of some federal rules, importantly Rule 23, on the enforcement of substantive law. As strategic actors, it would be rational for them to take into consideration how class certification doctrine in a case that does not implicate issues on which they have strong preferences might affect certification in cases that do. Alternatively, or in addition, if women and African American judges are more pro-plaintiff in cases raising some types of claims based on discrimination and inequality, and they perceive that the class device has been a valuable tool in the struggle for gender, racial, and other forms of equality, it may be that they have a more favorable view of the class device as a vehicle to provide remedies and achieve regulatory goals more generally. On that view, our results may be the first evidence that transsubstantive procedural law affecting access to justice is itself a policy domain in which minority group judges have distinctive preferences. Our suggestions regarding mechanisms that may help to explain why two women on a panel, but not one, are associated with higher rates of pro-certification voting and outcomes are more speculative and tentative. Recent scholarship on the gender gap in political discussions and decision-making illuminates some disquieting possibilities. This work has shown that at least in some settings, a decision rule requiring a simple majority is inimical to the ability of women to exercise a fair share of influence when they're in the minority, a disadvantage that continues in some contexts until women constitute a majority or even a supermajority. It suggests two distinct but obviously related mechanisms that may explain this pattern. One concerns how amenable to persuasion a woman's audience is. In their award-winning research, Tali Mendelberg and Christopher Karpowitz find that under majority rule in an experimental context, when women are in the minority, they are treated as having less authority, are accorded less respect in the deliberative process, and are less likely to be perceived as making influential contributions as compared to when they are in the majority. The authors detect no corresponding reductions for males on these dimensions when they move from majority to minority. A reasonable reading of this research is that holding constant the substance of a woman's contributions, she will be more likely to persuade others and affect outcomes when in the majority. An alternative or supplemental mechanism concerns how the deliberative context affects the substance of women's contributions. Mendelberg and Karpowitz find, again under majority rule in an experimental context, that women in the minority are less likely to express their sincere preferences as compared to when they are in the majority, an outcome the authors see as tied to women being treated as less authoritative, less deserving of respect, and less influential when in the minority. If the dynamics identified by this research are at play in our field, one possibility is that a woman in the minority who vigorously advocates for a preferred outcome is less successful because as a panel minority in a domain that, unlike employment discrimination, does not elicit gender-based deference, she is regarded as less authoritative and influential. Another is that the reinforcement of a female majority increases her propensity to advocate preferences that differ systematically from those of her male colleagues in areas without obvious gender salience. So we're open for questions.
Thank you so much. I think you both know how fascinating I find this research. We do have several questions already from the audience. Unless for those of you who did not see my note in the chat, please feel free to submit your questions using the Q&A feature. So the first question that we got in asked about whether you could potentially study class. Why did you limit the study to gender and racial and ideology characteristics? And is it possible to study class background? If so, how would you go about doing it?
Steve, I bet you're looking at me.
How did you guess?
The answer is, I don't know how you would study class. It would be very difficult to get data that would allow you to measure class in a reasonable way. I imagine if someone was committed to studying class, such that they were willing to make significant investments of time in learning about the background of a large number of judges, and they came up with some clever proxy variables. I can think of some that would be easy to criticize, but maybe something like whether they went to public school or private school, or I don't know, come up with clever proxy variables. It would seem to me tractable but it would seem to me like a dissertation project, such that someone was willing to make that really heavy investment in creating original data. I think that would be a really cool project.
I agree with that. It would be very, very difficult to do. In fact, I would have no confidence, frankly, that it could be done with sufficient rigor and consistency to make the results persuasive.
I mean, so the follow-up question was, do you think this might be a pretty influential characteristic, though, that we should, I don't know, somehow try to study?
I think I'm inclined to say, yeah, it might be. If we know anything from the judicial behavior literature, we know that intuition is an extremely poor guide to what's actually going on. So one of the things we mentioned in the paper, for example, in emphasizing that it's interesting that women are more pro-certification, is that the empirical literature finds no gender effect in abortion cases, finds no gender effect in sexual harassment cases, and therefore I identify those studies only to suggest that intuition just provides a poor guide. It does seem to be possible that class would be consequential. And it also seems to me entirely possible that as much sense as that makes, it might turn out not to be the case.
Great. I think the next question, I think you started to talk about a little bit during your talk, but which is whether it matters if the claims asserted are, say, securities or employment discrimination cases. And you might take a moment to address some of the other controls on the analysis, on the variables in the analysis.
Okay. The answer is that we don't have enough data to compare across policy areas with any confidence, because there are a large number of different policy areas. What we do have, though, in the model, is the way we address it in the model, is with policy area fixed effects. So we did code what the policy area was, and all of the estimates of the effect of party, race, and gender are conditional on controls for policy areas. So we know that it's not driven by policy area. It's not just that women happen to sit in circuits which have a higher percentage of certain kinds of cases. First of all, we have circuit fixed effects, but then additionally we have policy area fixed effects. I would think that is an interesting question. That's another great paper idea from the audience. Audiences always have great paper ideas. All the things we didn't do. We're working on another paper right now on pleadings, post-Twickball pleading decisions on the courts of appeals. And we've talked about other Court of Appeals projects, and one possibility we've thought about at some point in the future is aggregating all of the data together into a sort of civil justice Court of Appeals data set, which then might actually have sufficient data for us to start to drill down and make comparisons across policy areas. So I think that's a great idea. We treat it as a nuisance in the model by controlling for it, but we hope to investigate it in the future when we have a bigger data set. If anybody out there has a checkbook, they want to write us some checks so that we can hire more research assistants and collect more data, that would be great.
Actually, I have to say that sounds like a great project for the Civil Justice Research Initiative, so let's talk afterwards.
Okay.
Professor Burbank, did you have anything to add to that?
No.
Okay, great. So just more great ideas from the audience. The next question is, do you think it would be feasible and useful to study these questions at the district court level? Assuming, again, if you could get the data. Yeah.
Steve?
Trial court level.
Well, you obviously are not going to do a panel effect study on the district court. So that's would be a very different study.
May I add something?
Please.
Yeah. So I would also just add that that the literature on district courts, at least the literature that I think is high quality empirical design literature, has tried to just study some individual level effects. I'll confess that I have a paper that's basically finished right now studying trial court decisions in Title VII cases that were brought by the EEOC that some co-authors and I are going to wrap up very soon. I will say that our paper, like others, have found very, very weak effects. And in general, court on any issue, ideologically oriented issue, it appears that trial judges vote much less ideologically. It's not exactly clear why. Some people theorize that it's a docket thing. It's because they have a more bureaucratic routine set of cases than Court of Appeals judges. Other people theorize that it's the selection process of who becomes a district court judge versus who becomes a Court of Appeals judge. But in general, I would say the literature that is high quality empirical literature has found less at the district court level. And I'll just say, we do observe that cases before African-American judges do somewhat better with a small magnitude, and gender has no effect whatever in the outcome of cases at the trial court level. That's what we observe.
Interesting. So one person is asking, how do you identify the race and gender of the judges? How do you discern that?
Well, there's a good deal of data available about federal judges through the Federal Judicial Center, and you can research an individual judge. Moreover, the racial and gender complexion of the federal courts has been of considerable interest broadly for decades, and there's a lot of information freely available about judges if you can't get it from the Federal Judicial Center database.
So I'll just add to that the FJC, Federal Judicial Center that Steve's referring to, they have this biographical database of federal judges. It gives you their race and gender. You may be interested, I guess it's a sign of our times, so that's where we got it, from the government. You may be interested that it's a sign of our times that the last time I downloaded the data set, which was probably about a month ago for another paper that Steve and I are working on, they had significantly increased the granularity of the reporting of the judge's race as compared to in the past. They used to just say white, African American, Hispanic, Asian, Native American, and they now have further classifications, and they give combination classifications like Asian Hispanic or Hispanic African American. So it seems as if they're trying to give more granular information, which I believe comes where they're now asking the judges to self-identify their race and use more combinations when judges use combinations to describe mixed race categories. I thought that was interesting.
Sort of another kind of, I think, related question has to do with, were you able to study whether it made a difference where you had gender and race sort of combined? You know, did white women versus maybe African-American men have different types of certification decisions? So I don't know if you were able to study that, if you had enough data.
We looked at that.
Yeah, we looked at interactions of gender and race, and gender and party, and race and party, and they were all insignificant, meaning that I'm going to give one caveat, but meaning that, for example, women Democrats versus women Republicans, that was not associated with the differential effect of gender, separately from the direct effects in the model of gender and party. And likewise, African American men versus African American women. There was distinction, statistically significant distinction that was not in addition to the separate direct effects of race and gender, and therefore there's no evidence that intersectionality has effects on voting. However, I want to add the big caveat that there's not enough African American women to be confident about the specific lack of intersectionality as it applies specifically to African American women. Not enough data, but all the interactions were insignificant, and we report it in the appendix of the paper.
Interesting. One person is asking about, in addition to race, gender, and party, any statistically distinguishable trend in the probability of class certification based on the geographic regions of the Court of Appeals, or perhaps some sort of rural-urban divide?
The answer, stop. If people keep asking statistical model questions, I'm gonna keep answering. So broaden your questions beyond statistical model questions. But I will answer, and the answer is that's like
Policy areas.
Yeah, it's like policy areas. We treat it with a fixed effect, so we're only estimating within circuit, so we control for it. The question is, are there statistically significant differences between the probability of certification if you look at the dummy variables? The answer is yeah, there are. They're really not that big. So there are not huge effects between the Ninth Circuit and the Fifth Circuit, for example. That's something that Steve and I may discuss in another paper that we're working on right now. But we control for it, and there is variation across circuits in the probability of certification, but not that much.
There's lots more model questions. I think I'm going to jump in and ask a few broader questions. What's the takeaway here for if let's say if you're a policymaker or you're a practitioner or you're a judge? What's the takeaway advice or guidance that you would give from these findings? Maybe that's a question where Professor Burbank might like to jump in.
I'm not sure what the takeaway is in terms of policy advice, except, yeah, I guess I am pretty sure. I'm pretty sure that the appointment history that we've seen for the last 4 years is a scandal, and our results tend to suggest one of the reasons why. We have a situation where, as Sean pointed out, if you've got a circuit that has 20% women on the Court of Appeals, they're going to be in the majority only 8% of the time. So they're already underrepresented because of the panel system. And whatever the dynamic is that is causing 2 women but not 1 to affect the voting of males is really problematic, and it seems to me that our article is further evidence of the need for greater diversity on the federal courts of appeals.
I would add one word to that, or a phrase to that, would be like a vote. That's my recommendation. That's the recommendation that the paper vote in the next election, because of the fact that it has consequences. And I think one thing that the paper shows is that it has consequences even beyond, say, something like diversity, even beyond areas where we tend to intuitively realize it probably has consequences. They're more widely radiating, and therefore vote. That's my policy recommendation.
Well, I'm going to go way out here, and because one of the thoughts I had, having been familiar with the research before hearing this today, was whether there's going to be some critical mass of women. We've heard if Biden is elected that he's going to appoint a woman Supreme Court justice. So if we got to a point where we say had 4 women sitting on the Supreme Court at once, would that significantly, do you think, impact Supreme Court decision making?
I don't know, and Sean and I haven't really talked about this. I don't know whether and the extent to which, if at all, our results and this research are translatable to the Supreme Court of the United States, which, after all, doesn't sit in panels. and does at least now have 9 people on it. What do you think, Sean?
Why don't you recount the Justice Ginsburg quotation that you put in the paper? That seems relevant to me.
Which Justice Ginsburg?
About I say something at a meeting with the court.
Oh, right. Yeah, she was quoted by Adam Liptak of the New York Times as saying, she said would say something at conference and get no traction from her colleagues, and then one of her male colleagues would say essentially the same thing, and people would start nodding and agreeing and the like. And you know, some people, and I expect some federal judges will not like this paper, will regard the notion that there is gender discrimination, even if unintentional, on the courts of appeals as an affront. And but one presumably would have thought that the gender discrimination in Supreme Court arguments was not something that we would see. And yet you've had, within the last few years, you've had 4 or 5 articles that empirically support the proposition that women lawyers arguing before the Supreme Court are subject to gendered behavior, both by the justices and by other lawyers, and that women justices are themselves subject to gendered behavior. So that's my response to such a reaction.
I'll observe one thing further. Steve can correct me if I'm wrong, because Steve was the primary person who marshaled that literature in the paper, that kind of social psychology literature, political psychology literature in the paper. But what you talk, when you talk about critical mass and you say 4, it's interesting that the literature seems to suggest you need 5. That the focal point is being a majority.
Yes.
And that it finds using experimental methods that women who make arguments in the minority and women who make arguments in the majority, that their arguments in the majority are regarded as having greater kind of legitimacy or more as being more persuasive. But yet that majority minority transition in the way people perceive the persuasiveness perception of the arguments doesn't exist for men. So it's a fascinating and important literature that's been growing. And then it would suggest, Anne, that you just need 1 more 5. And then you have power, and then people listen.
Until there are 9.
And in some of the contexts studied, you need a supermajority. A plain majority won't do it.
Well, as I think, as RBG also said, until there are 9, yes. So, okay, back to some of the other more specific questions about the research. Do we know anything about en bancs in this area, or failed attempts to take cases en banc when such failed attempts are public?
I can only say that we have in our data, we have all of the en banc cases. We don't know anything about failed en banc cases, but we have when they did grant en banc. We didn't use, there are an insufficient number of en banc cases to like actually do a separate en banc analysis. And so we didn't use the cases, since our analysis required that the structure of the analysis had to do with what happens on 3-judge panels. So again, it may be that when we combine this, we're also collecting the en banc cases for pleading cases. And it may be that in the future, it's possible to do something with en banc cases when we have enough data in a kind of cross-cutting civil justice data set.
Sean, I think it's appropriate to add there the reason why we think the prior literature has found that women and men have different preferences only in a very narrow slice of litigation. And you know, one of the most prominent of these found it in only 1 of 13 types of case. And the reason relates to what Sean was just saying, and that is that those other researchers did not have enough data. In almost all cases, did not have enough data meaningfully to analyze the situation when women were in a majority on a panel, and therefore they didn't do that, and therefore one has to wonder whether their conclusions about the narrow slice of litigation in which it makes a difference whether men or women are on the panel is correct.
So to just amplify on that a tiny bit, yeah, I think that's an important argument that we're trying to make in the paper, that an insight is across the literature, there's a strong consensus that gender essentially doesn't matter to behavior on the Court of Appeals other than employment discrimination cases. That's the standard dominant view. And it's based overwhelmingly on null results for gender in research designs that did not isolate panels with a female majority. And we're just based on the assumption that if women have different preferences, we'll just see it at the individual voting level or at the panel level. And therefore those papers appear not to have contemplated that women may have different preferences that only become visible when they're in the majority. And therefore a lot of the literature that says gender doesn't matter, we should be skeptical of. More research is needed in order to know how much gender matters to behavior on the courts of appeals, because we have essentially no other studies that isolate female majority panels.
Well, maybe sort of a related question, does it matter published or unpublished? And can you look at that? There's a comment because the content modification explanation might not apply where a decision wouldn't set precedent.
Shall I go, Steve?
Yeah, go ahead.
Yeah, so so published versus unpublished. One of the interesting things about this, actually, this relates to another paper that we're working on with this exact data right now, or at least I should say we're supposed to be working on with this exact data right now, is one of the interesting things is that only about 1/3 of the cases are unpublished during the period for which we have both published and unpublished cases. So they say roughly, you hear statistics that in the federal courts, about 75% of cases are unpublished. So this is an area with a much higher rate of publication. Judges seem to want to be making law in the area of certification much more than other areas. There's not enough cases to just study unpublished cases. And so we don't know what would happen if you studied only unpublished cases. We do know, though, that in unpublished, the one thing we can't say is that in unpublished cases, they're much less likely to certify. So the average rate of certification is significantly lower. There are a lot of summary affirmances of denials of certification that are a paragraph and that are unpublished cases. And when you pool all of it, it turns out that all judges, African Americans, women, whites, Democrats, Republicans, all of them are less likely to certify unpublished cases. So it just kind of shifts the intercept of publication down, but there remains in the pool data the effect. So we can't study them separately. I won't belabor repeating that we may be able to in the future when we have a lot more data in different areas.
Okay, one person is asking, are the effects consistent between B2 and B3 classes? May overlap with the policy question.
Steve?
I don't think we do that in this paper. We may do something like it in another paper.
Yeah, we didn't disaggregate specific class action type issues. We did actually, in a model to test the we coded it, and in a model to test the robustness of the results, we included all of those into issue level variables, and it made no difference to the results. But we didn't study it to see what's going on. And as we keep saying, we're working on this other paper that's focused on the longitudinal patterns, and we're gonna, Steve in particular, wants to get into that possibility of interesting differences between B2 and B3 classes.
Well, it may also be the case, Sean, and it would be, you'd have to draw some inferences that by excluding the employment discrimination and other cases and finding no effects on our results, that is also inferentially probative of the same thing, I think.
Yeah.
I mean, obviously B2 classes include a lot more than employment discrimination cases, but that's probably the biggest set of B2 cases.
Yeah. But for the audience out there, I'll just say, if, as a social scientist, that our suggestion that the paper's packed. We're separately analyzing race, gender, and party. We're looking at the panel level outcomes, and then we have a long, complicated appendix looking at individual voting behavior in those areas, and it's just packed. And therefore, we couldn't grapple with all of the possible interesting issues. But we hope to continue to milk this data set, which took us years to create, to write new papers exploring some of your interesting ideas, including the difference between B2 and B3 classes.
Great. I think you're answering some of these questions along the way, but one person asked whether you could study it over time, and it sounds like you are doing a longitudinal study. Is that right? Did I hear you right?
Yes, it is right. We did only one slice of the data in 1995 in this paper, but it's not a longitudinal paper. We are now working on a big longitudinal paper.
Great. So here's a question not about the statistical model. Do you think this research suggests that we should change how panels are selected? Perhaps to move away from random assignment to more deliberate selection methods that make panels more diverse, even given the circuit court's current makeup?
I'm very uneasy with that. I've been exposed, I think, to a little bit of the literature on that and how you would do it in a way that would, particularly in these times, persuade people that it wasn't a rigged enterprise. I'm not sure. More than that, I don't think I want to say.
I'll just say a couple things, and that is, it's very difficult for me to imagine the court as an institution acknowledging that these characteristics are associated with behavior and outcomes of cases. And therefore, the kind of political reality side of it, that kind of acknowledgement is hard for me to imagine happening. I do find the idea intriguing and interesting. And it might be that people would be less freaked out by it. I don't know if they would be. Might be less freaked out by it with respect to party, because we're used to thinking of party mattering. And therefore, I don't know that it's unimaginable that there could be a time in which they say, it's like, look, in our administrative law, we have certain kinds of commissions that have party balancing requirements. So one might say, why not judges? Now, I'm not saying I think this is actually going to happen, but I like the question. I think it's intriguing, and I could imagine saying we should have party balancing requirements. So at least all panels are mixed. And with respect to party, the idea of gender and racial balancing requirements is intriguing, but improbable, and I probably should have said even less than Steve.
Okay, so we are slowly but surely working our way through all of the questions. So I will, we have a few minutes left. I'll just invite the audience to, if they have any more questions, to pose them using the Q&A feature. I do have a few more left here. One person asked generally, can you say more about the models? What variables do you use, and how do you control the endogeneity problem?
Well, I guess that's depends what endogeneity problem that you're talking about. Not sure what's intended by that question, but I will say two big things that we do. One big thing that we do that would be the most obvious problem that may be being alluded to is that we have year fixed effects, so we're using only within year variation, and that then controls for variables that are changing over time that would take the same value for every judge on a panel. So all kinds of economic changes, changes in Supreme Court doctrines over time, changes in attitudes toward women, changes in race relations in the United States over time are absorbed into a year fixed effect. So we regard the year fixed effect as enormously important to limit ourselves to within year variation. Likewise, with respect to circuit, there's really significant variation across circuits, and we limit ourselves to within circuit variation. I'll just since you ask and someone's interested, I'll say very quickly, variables measuring policy area, direction of the trial court outcome, a very important variable, whether there's a trial court sitting by designation, the defendant type, federal government, state government, business, law type, federal law, state law, both, whether it was a motion for certification or decertification, whether the appeal was interlocutory. We have extensive controls. We control for the things that are the dominant things that you need to control for that the literature suggests. And the paper's coming out in Michigan Law Review, and it's posted on SSRN. So if you're interested, check out the paper, and it'll probably give you more empirical detail than you want. All in the appendix, since it's in a law review, and that's empirical detail is generally not tolerated in the body of a paper.
Let me, Professor Burbank, did you have anything to add?
No.
Okay. Let me throw a more sort of comment / question at you. So one question is might the judges behave differently in different types of cases, like settlement, when they're assessing classes certified for settlement or for or a litigation class? And is that something where something strategic might be going on there, and we're able to assess for that?
Well, I mean, if you take a look at the Third Circuit, where I sit, that is to say, I'm sitting in my office in the Third Circuit, you will find that the class action jurisprudence of the United States Court of Appeals for the Third Circuit is among the most rigorous, which is to say anti-plaintiff, for litigation classes, and among the most favorable to settlement classes. Now, why is that? Well, one possible reason is that the balance of power shifts when you move from a litigation class to a settlement class. It moves from the plaintiff to the defendant. And so those judges who are skeptical of class actions, who are perhaps influenced by the views of the Chamber of Commerce and other like-minded organizations, might be perfectly happy with settlement classes, because if the defendant wants to settle it, fine. We're perfectly happy, it gets rid of some cases and the like. But the balance of power definitely shifts when you move from a litigation class to a settlement class. And it is striking that the Third Circuit's jurisprudence is so different when you move from litigation classes to settlement classes.
Yeah, really interesting. So I have finally worked my way through all the questions. If any final question comes in the next minute or two, I will pose it to you. I did want to share with you, there are also many comments posted about how fascinating and exciting this research is. So thank you again so much for coming today to present the research. I don't know if you want to make any final remarks, Professor Farhang or Professor Burbank.
No, it's been fun. I appreciate it.
Thanks for having us.
Yeah, and thanks to the audience for being so engaged. Really lots of great questions, really interesting discussion. Many people chiming in thank you right now. So thanks so much, really appreciate it.
Thank you.
Now the audience is joining me in clapping. Best to both of you, please stay healthy. Take care, thanks again.
Thank you.
Bye.